Trends in Criminal Animal Law panel. We have 3 panelists today. First up will be Laura Dunn. She is a staff attorney at the ALDF Criminal Justice Program. She helped draft an extensive animal cruelty bill in Oregon that's now been made into law, giving tougher penalties and sentences on animal abuse. She also helped draft an amicus brief in State v. Nix, which is a seminal animal abuse case in Oregon, and she received her JD from here at Lewis and Park. Then we will have Diane Balken, also from ALDF Criminal Justice Program. She's a contract attorney for them. She came to them after working for 30 years as a prosecutor at a district attorney's office, prosecuting homicides as well as other felonies, and then also animal crimes. And then we have Peter Sankoff, who is a professor at the University of Alberta Faculty of Law. He specializes in animal law, criminal law, and also evidence. Additionally, he's the author or editor of 6 books, and then he has 2 other books in the works right now. Thank you, Tyler, very much. Thank you, everyone, for being here. My name is Laura Dunn. I'm with the Criminal Justice Program, as Tyler mentioned. I'm going to be talking about case law. It's been a really, really exciting year for case law, especially here in Oregon. So I'm going to be focusing on a lot of the cases that ALDF, specifically CJP, was involved with this year. Obviously, we can't cover everything. And then Diane will give a talk about trends in criminal law and legislation. So the first case, which many of you have probably already heard about, this was State versus Nix. And the basic question that the courts were asking was, is an animal a victim of a crime? For those of us that are in animal law, that seems like a pretty, the common sense answer for that question would be, yes, of course. The animals who are abused, the animals who are neglected in these cases, you know, a cat who is kicked down the stairs, a dog that is lit on fire, those animals are undoubtedly victims in the common sense of the word. The defendant argued, however, that in this case involving 20 horses, that not the animal or the animals themselves, but actually the animal owner or society as a whole were the victims of the crime. So luckily for us, the Supreme Court here in Oregon took the common sense approach and said yes, so we're going to break that down a little bit and talk about why. So first, it's important to understand merger in Oregon. So under Oregon's anti-merger statute, there are as many separately punishable offenses as there are victims. So the key here is, how do we define the term victim? And of course, the legislature did not do that for us, so the courts had to tackle that. In practical terms, if animals are victims, that means separate counts for each individual animal that has been harmed. And as we'll talk about later, that has implications, especially here in Oregon, given the legislation passed last year. So the trial court agreed with the defendant in this case and said, yes, 20 different horses were neglected, but horses are property, so horses can't be victims, only people can be victims. And the outcome, of course, was 1 jail term, 1 fine, and that defendant's record could be wiped clean. So the state appealed, thankfully. And the Court of Appeals took this up in 2012. ALDF wrote an amicus brief in this case, and we argued that animals are victims, especially given the comprehensive scheme of legislation that we have here in Oregon, including aggravated animal cruelty, mandatory vet reporting that Diane will talk about in a moment. But the legislature's intent was very clear that the purpose was to help animals, not to protect society as a whole from these criminals who could go on to commit other crimes, but rather that animals themselves, the science is clear that animals are sentient beings, they suffer, they are therefore victims. Of course, the defendant appealed, and the Oregon Supreme Court just this year in August ruled that animals are victims of a crime. Here, they underscored that animals are still property. They did not really go out on a limb, rather they looked to the legislative intent of the substantive statute and found that animals can be victims for the purpose of merger. And so again, under ORS 167325, the secondary animal neglect statute here in Oregon, automatically, if 11 or more animals are found to be neglected, that defendant has committed a felony. So the number of animals matters, and that's why this case was especially important. Jake Kamens, who is the first ever in the entire country, the first ever full-time dedicated animal cruelty prosecutor, was just successful about 2 weeks ago now in a case involving nearly 170 cattle who were seized. They were extremely skinny, a body condition score for most of them ranging between 1 and 3. Eye diseases including cancer. Jake got a conviction on every single count that was charged for these cattle, which is huge not only for the number but also the type of animal. We don't often see that in livestock cases. This was a commercial cattle operation. So sentencing will happen in December, and NICS will come into play here. Each and every one of those cattle will be taken into account, so that is huge. And Jake works through Benton County, but he came through a grant that ALDF provided, and this is a pilot program that we're hoping will be replicated in other states throughout the country. So Pheasant is probably another case that a lot of you have heard about. Here the court tackled whether the emergency aid or exigency exception to the warrant requirement could apply to animals. So, of course, our common sense would say yes. These animals who are suffering in these situations, who are now, we know, victims, that the emergency and exigency exceptions that we apply to humans that are in these situations should also apply to animal victims. So luckily, the Oregon Supreme Court ruled the same day that the NICS decision came down. They ruled that that this exception does apply to animals. So in this case, an officer had probable cause to believe that a horse was being neglected. And there were two different exceptions that are often conflated by advocates and the courts themselves. So the key here to know is that the exigency exception requires probable cause. Emergency aid does not. The exigency exception, until this recent ruling, the court had only applied to humans, even though in articulating this exception, the court had said that it could, in theory, apply to humans or property. So the facts were really extreme in this case, which helped. Ultimately, this horse was extremely skinny. The officer was in a place that he was lawfully allowed to be. He was in a common driveway shared by a neighbor who had called in the complaint. And that officer, given his years and years of expertise, determined that this horse needed to be seized immediately without taking the time to get a warrant, or that horse would have died. So all of those facts, again, so important that these were articulated, gotten on the record at trial, and then the courts took that into consideration. So again, yes, this veteran officer really knew his stuff. The horse was in plain view, and the warrant would take, he had decided, up to 8 hours. So the Court of Appeals decided that the emergency aid exception, given that animals are sentient beings, the emergency aid exception, which had only applied to persons, should apply here to animals. The Oregon Supreme Court decided that because of the past articulation of the exigency exception, which again, as I noted, they said could apply to persons or property, they decided, well, we don't really need to go there with the emergency aid. We don't need to go, that extreme and talk about whether that whole person's term would apply to animals. We can get there through the exigency exception, and therefore they just ruled that because animals are property, that exception applied to this horse. So very important here that the court emphasize that this does not apply to all animals in all situations. Again, this was a really extreme case. I was just speaking to animal control officers a couple weeks ago, and underlining to them the importance of knowing that this is going to be a case-by-case situation going forward, that just not, any animal that looks like it might be neglected or abused, they really need to use their discretion there. And also the court, which does not always talk about technology, acknowledge that technology is changing. It's really a lot easier now for officers out in the field to call in, get a telephonic warrant. In this case, that wasn't possible, but just another factor that officers will have to take into account. And I encourage you to read the opinion. And this is Deputy Bartholomew with Grace, the horse, who unfortunately died after living many months in a happy situation, but that's her after recovering a bit. And just very briefly, we had a similar case in Massachusetts. That court, the highest court, decided that the emergency aid exception did apply to dogs who were found. Again, the officers were in plain view. These dogs, a couple were frozen, one was extremely skinny, didn't have food or water, and that court decided that the emergency aid exception did apply. So finally, or almost finally, State v. Newcomb, this is a case that is currently before the Oregon Supreme Court. Oral argument will be heard here at Lewis and Clark in March, but this was really, for animal advocates, a really bad decision by the Court of Appeals, and interestingly, it was decided by the same panel that decided the Pheasant and Dickey case. So just interesting how the same judges reached very, very different conclusions with very different rationales. So the issue here was, is it a search to extract and test the blood of a dog who an officer has probable cause to believe has been neglected? And therefore, do you need a warrant or an exception to the warrant requirement to test that blood? So there are laws in Oregon requiring, even if you do not legally own an animal, if, as in many states, if that dog is in your custody and control, you are legally required to render medical care to that animal. So our common sense answer to this would be no, because that person is in control of the dog. Why would we raise this huge hurdle in between that person fulfilling their legal duty? So the Oregon Court of Appeals, in its infinite wisdom, decided that yes, this is a search. The facts here, Oregon Humane Society was involved in this case. A humane agent seized a dog that had no food available. It was trying to eat some debris in a yard. It was dry vomiting. So ultimately, that officer decided, I need to get this dog care, took it back to OHS, and a vet at that facility examined the dog. They weighed and charted the dog's progress over time, giving it food as a normal person would, tested its feces as well as blood, and the court ruled that the weighing and charting was not a search, but the blood draw and testing was. And the rationale here was that a normal person without any, any specific expertise could just look at this dog and notice, oh, that dog is gaining weight over time. Whereas with the blood, that was information that was not otherwise exposed. So ultimately, the court analogized a dog, which is a living being, to a closed container and looked at other closed container cases from Oregon law. Again, this was the same three-judge panel as the Pheasant-Dickey case. So problems with this ruling, this really defies common sense. As I said, a caregiver is required by law to provide minimum care, and vets have duties to provide this care as well. So Scott Heiser, a director in CJP, wrote a great blog. I encourage you to check it out, about just what we can do in the interim between the Court of Appeals ruling and what the Supreme Court of Oregon will decide. This is limited only to Oregon. there has to be state action. Unfortunately, the court did not distinguish or lay out a rubric for us about what will constitute state action. OHS is kind of an anomaly in that it employs humane agents that are appointed by the AG's office. So it's still left unclear whether vets in private practice will be implicated in this kind of action. So we filed an amicus brief with a few other national and statewide groups, and as I said, oral argument will be heard here in March. And I believe Matthew will be covering the Animal Crush case tomorrow, and I see that I'm out of time. Ultimately, the Fifth Circuit ruled that the new Animal Crush law, so this was not the law at issue in U.S. v. Stevens, but the amended version was constitutional because it prohibits obscenity. They remanded that to the lower court, who will decide whether the actual crush videos used by these defendants or made by these defendants will constitute obscene material. So now I will turn it over to Diane, who will talk about trends in criminal law.
Thank you all for coming to this presentation. It was difficult when we prepared this to really reduce it to a manageable number of trends because there are so many. And the good news about what we do is we take baby steps, but we are measuring great progress in this area. In 2014, all 50 states now have felony animal cruelty laws. South Dakota was the last holdout. Now, some are stronger than others. Some really approach it very carefully, and we can do a lot for the animals that are victimized. Some do not, but at least we're thankful that all 50 states now have felony animal cruelty laws. We've made great progress in the area of pets in protection orders. I see this being related to criminal law because the way we deal with domestic violence cases and linked cases where we have the co-occurrence of an animal crime and a human crime, and how do we deal with this violence under the residential roof? And we have to deal with the animal piece. And the way we are successfully dealing with it is by making pets protected property. They, in and of themselves, are the actual protected property as well as the human. So you can see we've made great progress. In the pink, we have enacted pets and protection order laws, and in the orange, laws have been introduced. So we have them enacted in 27 states. In Colorado, we have both civil and criminal pets and protection orders, and officers are now understand that they are mandated to investigate these cases and process the crime scenes. The chronology of pets and protection orders is, I think, quite interesting because in the scope of law, look at from 2006 to 2014, that's only 8 years. Look at the progress we've made in a very brief period of time. Another area I think we've made progress in is veterinarians' duty to report. I've always felt that veterinarians do for cruelty cases what pediatricians do for child abuse cases, or coroners do for, death cases. So we needed to bring them into the fold, and I'm proud to say that Colorado was the 6th state or 7th state in the country to enact a mandatory reporting by veterinarians. We did it with the full support of the Veterinary Medical Association. We are also very lucky that in Colorado, they must turn over their records to law enforcement for an investigation of cruelty or neglect or fighting. So that helps us multifold. That means they don't have to have a search warrant and they don't have to issue a subpoena, and it protects the veterinarian for turning over the records. That is not true nationwide. There are some states, I'm sorry to report, where it is illegal for a veterinarian to turn over their records. And just this past year in Colorado, when we enacted a law, we have a wonderful statute called PACFA, Pet Animal Care and Facilities Act. It's a model for governing places that house certain numbers of animals, breeding facilities, groomers, hospitals, clinics, pet stores. And we now made it mandatory for PACFA inspectors to report cruelty. And so we are seeing this expand, that people that have to report animal cruelty. There's also been a recent movement in the no-kill measures. There was an initiative introduced it wasn't introduced last year in Colorado. There was an attempt made to follow through with an initiative on a no-kill. And what they want to do is make it difficult for shelters and rescues to euthanize otherwise adoptable animals. It sounds very good on the surface, but the language that was used, there can be several unintended consequences. And their goal is to increase the live release rate, which I think is something we are all supportive of, but you have to be very careful about the language that's used in these initiatives. But I see a growth in the movement. They picked Colorado, in my estimation, because we do have a very good transfer and rescue program, and our live release is quite high. So I believe that they will be trying to introduce another initiative this year. Oh, and I'm also not going to go through ag-gag because they covered it quite well in the earlier presentation, but I think that it's always looming there in the background, and I know we're going to face a quick reporting bill in Colorado. The other area that I'm aware of is, any of you familiar with the Paw Project out of California? Dr. Jennifer Conrad? Yeah. If you haven't seen the movie, it's really worth seeing. It's heartbreaking to see what the effects of declawing are. I can't believe that I was so undereducated on it. Declawing isn't just removing the nails. It is an amputation of the last knuckle of the cat's fingers. And they're doing a lot on not only domestic cats, but the large cats that are in zoos or in captivity. And it's a horrible procedure. But they've been very successful. They started in smaller jurisdictions in California, and they banned declawing. It might have been Hollywood that was the first one. I have not seen it successfully enacted statewide. The veterinarians are opposed to it, and if you don't get the support of the veterinarians on certain measures involving animals, it's not going to get a lot of momentum. And their attitude is they still want the veterinarians to be able to discuss the options with their clients. But just the suggestion that declawing legislation may be introduced forced a conversation in Colorado. And it forced the Colorado Veterinary Medical Association to come up with a different animal welfare statement on the topic, saying that they really do need to offer options other than declawing and to have a really engaged conversation with their client before doing so. But I think we're going to see this on the horizon as well. Dogs left in hot cars. This is a fabulous... Ian did it? And Vaughn? This is fabulous. These shades for cars to remind people that dogs shouldn't be left in hot cars, nor should children. I think there was just a death here within the last day. The 24th child, I think, in the country. So it's something we need to be aware of. This is a wonderful promotion. But because this is such a hot topic, we found that there are at least 14 states that have enacted specific legislation making it illegal for someone to leave an animal in a hot car or a cold car. I know Colorado doesn't have a specific statute, but we don't need to because our cruelty statute embraces this concept, and we could still charge someone with cruelty even without having the exact language. Breed-specific legislation. Yeah, and what's interesting, we were just talking about this at supper the other night, that it seems that the popularity of breed bans is waning. And I just downloaded this map from the American Kennel Club website, and they are on top of this because they are against breed bans. So what's interesting about Colorado is you see it's green and it says we have a prohibition on breed bans. Here's the problem. Colorado enacted a statute saying it is illegal to enact a breed ban. However, Denver has had one for long standing, and Denver is a home rule city. And so the Denver city government took a lawsuit to the Supreme Court, and the Supreme Court found that Denver can, in fact, enact a breed ban because they are a home rule city. So even though our state says it's against the law, the Supreme Court has said, no, it's all right because Denver's a home rule city. So what we are striving to do is make better dangerous or vicious animal laws, dangerous dogs, and enforce those laws in lieu of breed-specific bans. The Pets and Women's Safety Act was a resolution just introduced on the federal level. It's Pets and Women's Safety. It's a fabulous law. It really shows you the trend of everyone understanding the dynamics of domestic violence and how we have to consider the pets as part of the formula of breaking the cycle of violence. So this federal resolution intends to expand domestic violence protection to include pets as victims for interstate stalking, provides federal money and grant money, and it sets forth the guidelines to house women or men who are victims of domestic violence, and it adds veterinary care to be recouped as restitution. So this is a really big step on a federal level of making a difference for family violence. And it was referred to the subcommittee on September 26th, so this is kind of hot news too. We are lucky now that there are now a lot of national and local investigation and prosecution efforts. It really is sweeping the country, this trend, and it's wonderful. When you start to see these well-established organizations buying into the fact that we can no longer ignore animal cruelty cases, it has been a great benefit to the prosecutors in the trenches. One of the first was the Association of Prosecuting Attorneys. We call this the Heiser Referendum because Scott Heiser, the director of the Criminal Justice Program, was very instrumental in getting this resolution passed with the Association of Prosecuting Attorneys. And it basically says that we must recognize animal cruelty as a crime of violence and its connection to human crimes and treat these cases seriously and make them a priority. So this has been circulated nationwide, and what's great is we are reaching the really under-resourced rural communities with measures like this. The other way we are making progress by statements like this is to let the public know that we are talking about public safety, human welfare, and animal welfare, and we get a lot more mileage. We have the National Center for Prosecution of Animal Abuse. It is a program of the National District Attorneys Association, and ALDF is highly represented in all these groups. We are on the oversight committee. We provide monthly or every other month free webinars to prosecutors and investigators and anyone interested in pursuing and helping them to prove crimes with animals as victims. The National Sheriff's Association we will be absolutely indebted to for quite a while because of two efforts. Number one is this new website called the National Law Enforcement Center on Animal Abuse. And I have to mention, John Thompson is the individual we have to thank. He is the interim director for the National Sheriff's Association. And so we have this new website with a lot of resources free to the public to help prosecute and investigate crimes against animals. He also brought together a roundtable, and of course ALDF was also a huge participant, of all of the stakeholders involved in law enforcement and public safety to get together to say, you know, we need to have the FBI and these national level agencies take a closer look at animal cruelty. So there was a letter writing campaign to urge the director of the FBI to create a separate category of crimes, of animal crimes, and make it mandatory that they be reported to the National Crime Information Center. So they announced this in September, that it will start, the director signed in on this, that they will start tracking all forms of animal abuse under the regularly updated Uniform Crime Report, which, by the way, was established in 1929. And it provides national crime statistics. Just so to give you some perspective, the last category of crimes that I remember being added to this specifically, rather than put into a catch-all, was hate crimes and bias-motivated crimes, because we realized we needed to kind of measure how often they're happening, where they're happening, and what types of crime are happening. 4 types of animal abuse will be covered, and they are called Class A crimes: simple or gross neglect, intentional abuse and torture, organized abuse, and animal sexual abuse. So it's really great. Now that the FBI is recognizing it, I get to email these law enforcement agencies to say, you better start taking this seriously now that it's reached the level of groups and organizations you respect. It will take the entire next year, 2015, to implement this and make the changes to the NIBR system, which was created in 1989, and it's used by law enforcement nationwide. They'll start collecting the data in 2016. It'll become part of the regular crime statistics reports, and we are hoping that this will assist in evidence-based policies to reduce violence. So they will take it seriously that this is a measure of future violence. We have the National Link Coalition. Those of you interested in the link and the connection between cruelty to animals and violence towards humans on any level, it's a fabulous web page. There's also this bibliography. If you are ever looking for support to get evidence introduced at trial and scientific research on multiple levels, you can go to this bibliography. It is extremely thorough and complete and free. Colorado has the Colorado Link Project. This is also free. It's through the University of Denver Graduate School of Social Work. We provide professional toolkits for a variety of professionals, and this is the one, for example, for prosecutors, and you can click on whatever resources you need. There has also been a huge trend in veterinary forensics. We can't do what we do with crimes against animals without some medical, scientific testimony. So this growing wealth of information among veterinarians worldwide is really helping us. They now have master's programs and graduate programs all over. There's the International Veterinary Forensic Sciences Association. I know we have some international attendees at this conference, and I would urge you to go to the conference in May. It's a fabulous place to network and learn about what's happening in other countries and learn the state of the art. They're getting so sophisticated with investigating animal cruelty crimes. There's a woman at the University of Florida that is analyzing DNA from horses with their known exact time of death, and she's extracting DNA and RNA to try to determine time of death. So it's really some cutting-edge science that's very exciting. And if we can be of any assistance, please don't hesitate to contact me or Laura. Thank you. Or ALDF Range.
All right. So I'm here today to talk to you about Canadian animal cruelty law. And I recognize most of you aren't from Canada or perhaps have no interest in Canada. But I'll do my best to make it interesting. I'm hoping that some of the trends that I'm going to talk about reflect really on animal law, whatever jurisdiction you live in. In fact, I'm going to try and talk about themes that are sort of interest really about animal law more widely, again, wherever you live. What's sort of interesting, I think, about a lot of the things I'm going to talk about is how recent they are. In fact, that's why I really wanted to come to this talk. I really wanted to be here because I spoke here for the first time in 2008, and had I come here and done this presentation in 2008 and talked about what's happening in Canadian animal cruelty law in 2008, I would have said nothing. Nothing is happening. That's how bad it is. But it's amazing that since 2008, actually a lot has happened. Now, I choose my words carefully. The theme is lurching forward. I chose that title very carefully. It means sort of a spasmodic movement of a little bit of development. But I chose it carefully because I really wanted to end the day, because this is the last talk of the day, and I did want to focus on some positive things. So you'll notice that in my talk, I'm going to talk about some good things. I am going to talk about some things that I've noticed that are going well in Canada, but I don't want to mislead anybody. So let me say from the outset, things are not going well in Canada. Okay, I'm going to show you things that I think are positive, but I did this whole presentation. I'm going to show you all the good things judges are doing. I'm going to show you judges are good, some legislative things that are good. I mean, I literally did this whole presentation, left for a week on vacation, and MFA released this major investigation into an Alberta slaughterhouse where not only was the ordinary horrible cruelty going on, but Canadian federal investigators were standing by watching and even helping out with the cruelty that was taking place. That's how horrible it was. So, like, I was tempted to change my entire presentation and the title, but I held fast, and I'm going to hold on to lurching forward, okay? So we're going to stay positive with lurching forward. And I'm going to focus on three key themes as part of, just to show you what I think is going on. And again, this is not to show that everything's rosy and we're doing great, but three things that I think are worth looking at in Canada right now that are symbolic of things. One is an important one. I do still believe that little things matter, and I'll show you what I mean by that as I explore this idea. I still think it's important to convince judges and legislators that animals matter, and when I see that coming back to me in judgments, I think that's important, and I think we need to use that and move forward on bigger and better things, because you can't step forward into bigger challenges until you have recognition from judges that you're actually, they're ready to accept these changes, and I'm seeing that happen, so I want to show you how that's happening. Two, in Canada, new players are starting to change the dynamic. Canada is becoming a very complicated framework with a lot of players, and that is complicating our framework, so I'll talk about that. And three, I can't help myself. I'm going to talk about federalism, which will probably bore you, but it's an interesting problem in Canada, so I'm going to talk about how it's changing the playing field in Canada. So I'm going to start about, are we getting through? Because I've been coming to these conferences for a long time, and it's always been a major theme. A major thematic issue has been the question of, are we getting through to judges? For years, we're always getting these bad decisions back. So every time we try something adventurous, we're getting bad decisions. It's like, okay, let's do this. No, we're losing. This is bad. We can't win. And we always keep preaching. I've read a lot of these articles where we're saying judges just need to start getting it. We need to say, okay, when they get it, we'll actually win some of these cases. But I do believe that change comes through small victories that accrue over time. So when you start getting these changes, then we can start pushing for more aggressive change. So I guess it's helpful, I think, to reflect. And that's what I tried to do over the last couple of years. I tried to look back and say, well, are we winning? And luckily, I'm a law professor, so I get that opportunity. And the opportunity I have is I read a book on criminal law, so I have to do a new edition. So I did the last edition in 2009. And then I now have to revise it. So before this conference, I had to revise this edition. So I went back and I looked at 5 years of jurisprudence. And I have a chapter on property crimes where animals fit. So I looked at 5 years of jurisprudence. And I said, well, what did it tell me about animal crimes? So I had to get a research assistant. They got every single cruelty prosecution and sentencing day. And I had them all in a big pile. And I looked at all of them. So what did they tell me? And they actually told me a lot, and that's what I think is so interesting, and that's what I want to present to you today. And I call these the winds of change, because I don't think they're earth-shattering, but I do think they're interesting. So I'm going to start with a really weird one, but I think it's an interesting one. Bestiality. What the hell? Let's talk about bestiality. Because I think it shows a really interesting change in attitude from the judiciary. I know that's weird, but this is what I saw. In 1998, the leading decision that's talked about in my book is a case called Ruvinsky. And the Ruvinsky Decision took the standard approach. And this was reflective of the classic approach towards all animal issues. And I state, this is like Professor Sankov's law of animals. When there is a neutral interpretation, the judge will always take the interpretation that is least favorable towards the animal. That's not a legal principle, but it is a common theme that emerges in animal discourse, right? So the judge, I don't think, did anything unreasonable here. The judge just said it has to be sexual intercourse between a human and an animal. And the judge actually applied a long history of common law. So this was a case where the guy only took his finger and did things that you wouldn't want to imagine. And he did all sorts of things with the animal. The judge looked at all the case law and said, bestiality comes from buggery, did a long statutory analysis. Well, this is a crime against human morality. It's not about protecting animals. Acquitted. Okay, and that was the standard law. So you couldn't bring any types of crimes involving bestiality that didn't involve actual penetration. That was the common law. So suddenly, along came a new case, same facts, 2013, 15 years later, and the new judge just says, I'm not buying this. Just sweeps it away and says, forget it. He looks to evolving social norms and just says, and I think the language is what's interesting, because the judge says, members of our society have a responsibility. He starts looking at animal welfare language out of nowhere. It's just in the decision. And the purpose of the bestiality provisions is to enunciate social mores, and these include deterring animal abuse. So suddenly, the judge says, I'm not buying any of that stuff. 15 years later, we need a new interpretation of this law. And the focus is on the vulnerability of the animal. Now, I realize this is just a bestiality case. We don't get a lot of these in Canada, apparently every 15 years, and therefore, it's not a big deal. But I do think it's interesting, because the judge is willing to go outside the box. And that case does not stand alone. What else is going on? Sentencing changes in 2008 took place in Canada. New maximums came in. That was the first change to the Canadian Criminal Code in a long time. They upped the provisions, 5 years indictable, 18-month summary. They were up from 2 years. So just to make this clear, it's not that clear. Previously, the maximum was 2 years for an indictable offense, 6 months for a summary. It went up to 5 and 18 months. This is one of my favorite quotes ever. It's so good, I actually stole it. It's a New Zealand legislator, but I just love it. This is what the New Zealand legislator said. Parliament has a duty to protect all living beings from acts of cruelty. Judiciary requires a strong message. You can read it. I love it because it's true in every sense, right? They do have a duty to protect all living beings. And honestly, going to 5 years is the absolute least they can do. And I say that because if they ask me what they could do to fix the law, there are 500 things they could do that would be better. This is the absolute least they could do. And that's what they did, right? That's the only thing they did. Our law, trust me, is a shambles. But they fixed this. That's what they fixed. And I was skeptical because I'm not a big fan of raising sentencing maximums. I don't really think it accomplishes all that much. And I wasn't sure it would do that much in this case. But nonetheless, the initial reviews were not that favorable. The first book to ever be released in our country on animals and the law was by a friend of mine named Leslie Bisgold. And she reviewed in 2011, 3 years after the sentencing provisions came down, and said that the following. There have been almost no cases where anybody had ever gone to jail in Canada for animal cruelty. A few isolated ones here and there. This was one of the most famous cases of a wonderful gentleman who stabbed and stomped a cat to death because the owner didn't want it anymore. So decided to stab it and then stomp on it and got 1 day in prison. She cites a couple of other cases, even more recent, 2010, involving extreme neglect, a woman who dragged a dog down the road, 2007. As of 2010, the bottom line, prison, very, very rare. So, not much going on. That is no longer the case. The Canadian judges suddenly have gotten the message. So if one thing is taken off in Canada, it's sentencing. And what's amazing, again, what I've seen from my research, is how dramatic the surge has been. Out of nowhere, judges are suddenly getting the message that Parliament wants higher sentences. And they are giving out higher sentences. I'm not going to tell you that every sentence has been super, super high, but most of them have been along these lines. So again, the language is what I think is interesting. The judges have recognized that they want social values, demand higher respect for animals. This is just one decision. You can find 3 or 4 where the judges have stated, we want higher respect for animals, we demand higher sentences. The results, and let me stress, almost all of these are the usual intentional malicious cruelty of companion animals, but look at some of the results that we're seeing. The case I just showed you, no guilty plea, first offender, 90 days imprisonment. You can see some of these here with a guilty plea, 6 months imprisonment. First offender, guilty plea, 6 months imprisonment. I know for Americans these don't look high. For Canadians, these are very high. Dog order, and then along comes the big one, a recent case with an extremely lengthy beating of a dog, 2 years imprisonment, one of the highest cases ever awarded for an animal case. And again, almost as important is the language. The penalty's good, the judicial language shows a change in attitude, and I'll show you the shift. So here's the different attitudes. Here's the Paw case that I showed you, 1997. Here's what the judge said. Well, suffering wasn't that extensive. You know, this type of offense doesn't happen very often. We don't need to worry about this. You read through that case, it's an anachronism. It's not that old. 1997. And here's 2014. Extreme degree of violence. They're starting to get the idea. It's a breach of trust. I want to see language that keys into sentencing principles we understand. Dog is not a garbage. It's not an object. They're starting to key into language we can use to build on. Now, that's good. I'm not a big fan of these punishment orders. I am much more interested in if I have to give kudos to Parliament, and it hurts me, but I'll do it here. I'm not trying to be flippant, actually. I just think Parliament needs to fix the cruelty laws and the sentence laws, but I will give them kudos. The one thing they've done properly is they fixed the Prohibition Order section. That's the one thing they did that I think was actually useful. Here's why. When they amended the sentencing provisions, they also amended section 447.1 of the Criminal Code. And here's what they did. And this is also, they didn't do that much, the judges did it. So I'll give the judges some kudos. The court can now, they couldn't do this before, but they can now prohibit an accused from owning during any period the court considers appropriate. Before Parliament amended this, the judiciary was limited to a 2-year prohibition order. But now, the court can do it during any period the court considers appropriate. Now remember, I'm more interested in attitudes than I am in actual results. So let me show you what I mean by attitudes. There's no maximum, but on the second offense, there's a minimum of 5 years. Now, I'm a criminal law professor. Take it from me, that to me as a criminal law professor, this is almost code. And here's the code. When they put a minimum of 5 years for a second offense, it's kind of like a code. And what they're saying is, for the first offense, it's 0 to 5 years. And for the second offense, it's 5 years plus. Not guaranteed, but that's kind of the code word we're giving you. That's the way it works in a lot of other offending. That's what I thought would happen. All right. Prohibition orders are actually fairly controversial in a lot of areas. They extend beyond sentence. They're not tied to sentences. They prohibit persons from exercising their normal property rights. So we have them for firearms as well. You can't own your firearm. Courts in the past have expressed some reluctance about prohibition orders because they extend well beyond probation orders. They just extend into as long as the court wants to order them. And in the firearms context, prohibition orders are given out carefully, so they have to weigh and balance very carefully the competing interests. Maximum terms reserved for the worst cases. Safety, of course, is considered, but the rights to participate in the activity are carefully balanced. Okay? Now, do I like prohibition orders? I like prohibition orders. They're fantastic. Why? In case you're not aware of what a prohibition order is, let me explain. It bans you, once you've been convicted, for being anywhere near an animal. So that's the best thing possible. You're nationally registered, which in the old days didn't mean much, but with computers and the way databases are shared now, it's great. Breach is an automatic offense, so it's punishable by up to 6 months imprisonment. There's no need to prove cruelty. You're with the animal, guilty, done. That's the end of it. Okay, it's automatic, so I love it. Now, to get back to my earlier point. From 2008 to 2010, as I suspected, the orders that judges were giving out were mostly 2 to 5 years in duration. That's what I thought was going to happen. It's like, okay, 2 to 5 years. And then out of nowhere, one judge started giving higher orders, and we started to see a spike. It was just ridiculous. So in Rogers, like all horrible cases. So one case was horrible, and trust me, they're all horrible, right? Guy kills a puppy by throwing it down the stairs, 10-year prohibition. Kills a girlfriend's cat, 10-year prohibition. Worst case comes along, 25-year prohibition. We get some more severe abuse, 25-year prohibition. Society has long moved forward from the notion of animals as mere property. While man continues to have dominion in a civilized society, that's power coming by significant responsibilities. Again, love the language. I thought that was great. I didn't know what was coming. In Edmonton, my own jurisdiction, we had a horrible case of a young offender, 18 years old, killing and mutilating a family dog. A lifetime prohibition order. I almost fell over. You can't get that You can't get that for firearms on a first offense. It's impossible. But he got a lifetime prohibition. So this guy's 18. He will never live with an animal again. And I'm like, okay, isolated case, right? No. We have a mentally ill young woman, also also young. She tortured several young animals. Lifetime prohibition order. Okay, lower courts. No, this is confirmed on appeal. So we now have appellate authority confirming a lifetime prohibition order for a first offender. And here's the beauty. We have appellate language. She's lost the privilege of having the companionship of animals. That's what I call winds of change. The right types of language from higher courts saying the right things about animals in these types of settings. So we're seeing things saying, I don't want to get too positive, remember, government inspectors helping out. Just trying to keep it all in balance. But there is positive things here. We're seeing good sentences and some good prohibition orders, at least in these types of cases. What else is happening in Canada? I call this the power of one. If I had an achievable wish list, it's already happening here. Of course, things happen here faster. I get here, I have this whole thing planned out, and I read the ALDF newsletter. And apparently you guys have already done this. I'd like to convince every major Crown's office to designate one prosecutor to handle animal cruelty files. It seems to me to be the most logical thing. It's already been done with sexual offenders, I mean, a long time ago, with drinking and driving files. It's just logical, but it seems to me, given Canada's complex structure involving animal cruelty, it's even more necessary in this area. The advantages are overwhelming, and we've already seen the results. I actually think it should be part of our platform for some of the major advocacy organizations. Why? First of all, our cruelty offenses are multifaceted, giving the provincial and the federal jurisdictions that we'll come to talk about in just a moment. Second of all, the issues of proof are very complicated. They're just, I could get into that at length, but the issues of proof and when you need to prove what is difficult. And the truth is, I've dealt with prosecutors who are dealing with animal cruelty offenses for the first time. They just don't always get it. And they don't always get it, and they don't know what they don't know. And it takes time for them to see the differences between a human victim and an animal victim. And this is the big one. No matter for all the big cases I've just shown you, every time you deal with a prosecutor who doesn't understand the seriousness of the matters involved, it's very frustrating. All of us have felt this. Anybody who's felt this, I could talk about a conversation. I'm being recorded, so I can't do that. I would talk about a conversation I had with a very, very senior judge who I had two conversations with very, 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 very senior judges. One of them was wonderful. One of them still showed me that there was serious, serious bias against animals in our country. And that's just the way it is. One of them got it, one of them didn't. And one of them made a flippant joke that showed they just don't get it. And that's just the way it is. And it's no different with prosecutors. You get the wrong prosecutor, your case isn't going anywhere. You get the right prosecutor, they get it. And I'll show you what I mean by that. If you have a prosecutor who sees these cases all the time, they understand which are the right cases to move forward and which are the ones that aren't as important. They get it. But here's the big one. What I found out in Edmonton is we think, or at least I sometimes used to think, that everything's electronic now and all the cases are reported and all the relevant precedents are out there. They're not. We're still in a jurisdiction, I don't know what it's like here, where a lot of the major precedents, where that guy who was about to show you got sentenced to a huge whopping sentence, is just transcribed in some local courtroom. It's hidden away somewhere. And nobody knows about it except our local prosecutor, who happens to be the one doing all the animal cruelty files. So he has them all, but no one else does. And that is a problem still, even in today's digital age. He also knows when to proceed federally and when to proceed provincially. Hold that thought. I'll come back to that one. How do I know about the power of one? Because in Edmonton we've had an animal protection unit, which essentially means one person, since 2010. Remember all those great sentences I showed you? They're all swamped by Edmonton, one jurisdiction. In the last 4 years, we've had more than 10 cases with offenders sentenced to more than 10 months imprisonment. Just one city. That's how many he's managed to put away, is more than the rest of the country combined. Isn't that amazing? Why? Because he has all precedents. So he goes to his local judge, and he says, well, I put all the other people away, you better do it too. That's how he does it. It's not rocket science. That's the way it happens. We're a common law jurisdiction. Case go forward successfully. And guess what? That case I showed you earlier, R versus Bestiality, 18-year-old killed and mutilated his family dog to impress a girl. It's the highest penalty ever handed out in Canada. It's not reported. 26 months imprisonment and a lifetime ban on owning a pet. That's the case. I can't even get a transcript of it, but it's been reported in the paper, and I know about it because he's told me about it. That's what we got. We want to set a precedent that his behavior is not important. Okay, I hate to do this to you. Very quick constitutional roundup. Ready? have to tell you a little bit about constitutional law to set the foundation for where we're going. In Canada, the Constitution Act of 1867 decides jurisdiction, similar to the U.S., so it's not that crazy. The federal government, in contrast to the U.S., has exclusive jurisdiction over criminal law. So the ALDF ranks all the provinces for all their wonderful anti-cruelty statutes, but it's a bit of a mirage, because realistically here it's ranking all your state criminal, anti-cruelty statutes, but in Canada it's not doing quite the same thing, because realistically the Canadian Criminal Code is the only cruelty statute. All the others are regulatory statutes that are doing something else of what we're not entirely sure. That's what I'm going to talk about. The provinces have jurisdiction over property and matters of a local nature. Cruelty against animals is pretty clearly within federal jurisdiction. It's never been litigated, but it seems pretty clear that it's within federal jurisdiction. The question that remains to be seen is whether provincial laws regulating conduct towards animals invades federal jurisdiction, which is where I'm going. Let's just say, I'm not going to bore you anymore about this. The Supreme Court of Canada generally bends over backwards to let both jurisdictions legislate. But there are limits, and I'm going to discuss whether we are nearing those limits. To make a long story short, I think the answer is yes. I don't know if we're crossing them, but we're certainly nearing them. And I'll show you why. The provinces have exploded with I can't say anti-cruelty because that would be criminal legislation, so anti-distress legislation, okay? And it's been spurred pretty clearly by federal inaction. So the Canadian Criminal Code is terribly written. It's really poorly designed, despite the sentencing reforms I showed you, and it has a lot of flaws in it. We have been unable to reform it because of consensus at the federal level. So the provinces, unhappy with the federal laws, have made up their own laws. Right? The question is whether they can do that. It's very hard to prosecute offenders, especially in neglect. In Canada, we have one neglect crime. You ready for this? It's called willful neglect. You can only be prosecuted under the criminal code if you willfully neglect your animals. You got that? Normally, you neglect your animals because you forget about them. But if you willfully do it, you get it. Very hard to prove willful neglect. It's been led by BC, Ontario, Manitoba, and Nova Scotia. Provinces have filled the void in various ways. The less controversial ways is by creating a whole bunch of duties of care and regulatory frameworks. I'm not going to get into those. That would take all day. They've set up things about dogs, sled dogs, and zoos. The more controversial provisions are general ones about causing distress. Because under the criminal code, we punish cruelty. Under the provincial law, they punish causing distress. The question is whether there's an overlap. They also punish certain types of neglect. The problem is that the provincial laws have very high penalties that sort of look criminal. In Manitoba, for example, a first offense subject to 6 months imprisonment. Nova Scotia 2. In Alberta, you're only subject to a fine. So in Alberta, it's not that bad. Now we get to British Columbia. 2 years, $75,000 fine. Ontario, 2 years, $60,000 fine. Now let me remind you what those criminal code penalties were. 2 categories, summary conviction and indictable. I should just tell you what those are. Summary conviction are the more common ones. In fact, most offending should be summary conviction because indictable is a jury trial, superior court. It's the most serious offending. Summary conviction is 18 months, $10,000 max. So you may notice that you can be punished more heavily for a regulatory provincial offense than a criminal code offense. I'm not a constitutional genius, but I find that a little bit unusual. That's all I'm going to say about this. Other people are saying other things. Direct constitutional challenges have been brought in Ontario. And let's just say that if successful, they're going to shake the whole foundation of what's going on in Canada. Because they're not just challenging this. They're also challenging the definition of distress. I'm less convinced by this one. They're also challenging the very foundation of our prosecutorial system. Because Because right now, we have our entire investigative structure is done by private agencies. The SPCA does most of the investigative work across Canada. We use the British model, and they're saying there's a problem with that. It confers the power of the police to a private organization with no public oversight. There's a fair bit of jurisprudence in Canada saying that public oversight of police bodies is a good thing and a constitutional requirement. I don't know what will happen with this one either, and I'm unwilling to speculate, but I'll just say that I find it interesting. They also note that the OSPCA raises funds from the animal it seizes. I don't know about that one. And of course, that pith and substance argument is the same one I raised earlier. Essentially, they're saying this is a criminal law. And what they mean by that is you're exposing people to criminal prosecution without criminal protections. So people subject to the Ontario law don't get to be proven guilty beyond a reasonable doubt. They don't get to be, they do that. There's no mens rea requirement, and there's none of the other classic protections. Severity of the penalties characterize the act as criminal law. I won't go through all this, but I'll probably be back here in 2017 to tell you what happened. Win or lose, careful thought is required. All those provincial acts look good on the surface, but they're causing some dilemmas, and let me tell you what they are. First of all, I think there's a little bit too much reliance on the provincial offenses. Everybody's running to say, let's charge them with the provincial offenses, and I'm like, we're losing sight of what is criminal conduct here, and the criminal conduct is important. Sometimes these charges need to be brought criminally, and what bothers me the most is, why is it always in farming cases that we're charging under the provincial laws? All the prosecutors want to go, well, in farming cases, let's charge them under the provincial laws. And I'm like, no, let's charge them under those federal laws where they deserve to be charged, especially when in those MFA cases they're beating the animals. Why charge them provincially? Because it's easier to convict them. And I'm like, that's not an answer. They deserve the stigma of the criminal conviction. A lot of things come with a criminal conviction. Let's get those things. Sentencing is also a problem. You think 2 years is 2 years, it's the same thing, but it's not. In the criminal law context, offenders are punished because of mens rea. It justifies a punitive response. There's a lot of authority to suggest that judges should not impose sanctions to punish the same way. I won't bore you with this whole quote, but they shouldn't punish as heavily for regulatory offenses. That's the basic underlying theory. Whether every judge adheres to that or not, I don't know. But I believe in that. There is something to that. I'm running a bit long, so I'll just rush through the last little bit. I can't ignore the rise in the MFA. Mercy for Animals has come to Canada in a huge, huge way. And it has done a lot of stuff. So I'm going to run through what it's done very quickly. It's done all the usual stuff. Same stuff it's done here, very effectively. Here's the interesting thing. Canadian law permits evidence gathered by non-state actors to be admitted without constitutional scrutiny. Whether it's taken legally or not, doesn't really matter. Anything can come in Canada. However, I say that subject to some caveats that I'm going to get to in a moment. So they've been taking all this, and there's been some speculation that prosecutions will result. And yet prosecutions have not quite been resulting, and we're not entirely sure why. So it's still early days, so I can't be definitive. So let's talk about that. First of all, the good news. Obviously, raising the profile of abusive farms is the main thing. Whether prosecutions result, to me, is sort of, it's icing on the cake. Really, they're exposing, the main things they're doing is exposing what's going on in farms, and the inaction of federal investigators, to me, is the biggest thing that they're doing. So that, to me, is the main thing. One abuse in Alberta egg farm led to a ban on battery cages for new farms. One case has led to charges, and I'm going to talk about this case in a moment, a Kitchener turkey case, so I'll come back to that one. But 2 cases have been on hold. A major case in BC has not yet led to charges, and a case in Quebec, I've been informed by my colleagues, may lead to charges soon, but is on hold at the moment. So I'm kind of interested in why that is, because that's a while. Most criminal cases, the evidence is pretty clear, it's there. Most criminal cases would have proceeded by now. Why is it taking so long? This is pure speculation on my part, so really, I'm into the realm of speculation. I don't think prosecutors like it. There's this agency out there doing its investigations, and I think they're uncomfortable. I think there's a disconnect there between the prosecuting agencies And that's what I think is going on. And I think there is an underlying constitutional battle. This is, again, way down the track and a lot of speculation on my part, but I just say this. I said to you 5 minutes ago that there's no constitutional problem with gathering evidence and presenting it before a court. We've never had a third party come forward and say we're going to systematically gather evidence over a long period of time because the federal investigators won't do their job. Something tells me that the courts won't like that. I just feel it in my bones, and I've run across a few constitutional scholars, and something tells me that in the long run, the courts will craft some way to say, wait a minute, so the police can't do this, but they can successfully fail to do this and have a third-party agency over time just keep doing this and then benefit from the profits of it. I can see the courts getting clever down the road, but I'm just throwing out speculation. So I don't know where that's going, but it's something I'm thinking about. And I'm troubled by the charging decision. And I'll tell you what I mean by the charging decision. It just goes back to my constitutional problem. Why distress and not intentional cruelty? I didn't show you the cruelty in Kitchener turkeys, but you've seen enough Mercy for Animals footage at this conference to know what took place. There were pipes involved, there were turkeys on the ground, there were beatings, okay? And what was charged? Not willfully causing unnecessary suffering, causing distress. Why were they charged? Not charged with the willful causing of cruelty. You read the quote from the inspector, seems to me that they think it's cruelty. I don't get it. Everybody's talking cruelty. No charges of cruelty. And what did the accused do? They launched a constitutional charge. They said we should have been charged criminally. So they've asked for the charges to be stayed on the grounds that this is unconstitutional. We deserve criminal protections. And that's where I think all this is going. I'm troubled by the idea. I think these charges should have been laid criminally. And I think this constitutional shuffle is going to lead to problems down the road. So I leave this plea to anybody who watches from Canada and any Canadians in the audience. Down the road, all of this stems from the problems in the federal laws. We've abandoned federal reform. Everybody says federal reform is just too hard. Cannot abandon federal reform. The problem is that we've tried to do everything in the federal laws because they're terrible. Let's just fix the cruelty part. That's what I think we can do. Let's find some consensus, fix the cruelty part, and just do what they've done in every state in the U.S., create a felony cruelty law, civil one, that says what's aggravated cruelty, what's willful cruelty, reckless cruelty, criminal negligence. That's it. Leave the rest to a day when we can make that change. Let's blow some winds of change through the federal law, get all that antiquated law out of there, fix what's fixable. That's what I think would be a nice change moving forward. Speaking of small steps, we're always trying to move small steps forward through the law, and part of that is spreading dialogue about the law. So with some colleagues, we have a new book coming forward that will explore all these issues in greater depth, and I hope it's of interest to you. I know sometimes it's customary, and with pet pictures, I don't have any pets, but in October my house is sometimes invaded by small alligators and dinosaurs. So, thank you very much for your time. I did not do that. I didn't know how to fix that, so I did not do that.
Yeah.
Okay, great.
Okay, so we're going to open up the floor now for questions. And if you want to just identify who your question is for, and then we'll go from there.
Peter, I was wondering, you were saying that the charges are being made with the provincial laws. I'm wondering who is making the choice to choose that? In other words, who are the prosecutors in Canada? Are they prosecutors who are elected officials at the provincial level, or are they federal prosecutors, and how do they make their choice?
You know, that's so interesting in Canada. It leads, I wish I had more time to discuss some of the prosecutors in Canada are all provincial attorney general. All of them. There's no federal prosecutors who deal with these sorts of offenses. So it's all provincial attorney general, and that's what I think leads to a lot of the issues that we talked about. So these are just provincial attorney general who deal with every type of standard violent crime. and they don't deal with a lot of these issues, and these cases cross their desk, and they have to decide which type of offense to deal with, and they get to choose which offense they feel best fits the crime. And I think that also leads to some of their I didn't get to expand upon the issue of why I think they're uncomfortable with some of the stuff that's crossing their desk. In Canada, they're not elected. They're not elected district attorneys. They are appointed public officials, and there's this long-standing trend that the Crown Attorney is acting on behalf of the Crown and has a real important mandate to act in the public interest. And that's why I think there's this sense of discomfort. They feel a little bit of concern about taking this evidence that might have been gathered in this way. And I don't know if that's the case. I just know I've dealt with some Crown attorneys, and I've talked with them about it. When they get things like this, it's not like the guy who crosses his neighbor's. I sense that discomfort because it's not like the guy who's crossed into his neighbor's yard and found a dead body. He crossed illegally into his neighbor's yard and found a dead body. And said, okay, well, that was illegal. I found a dead body. That's a bad thing, but they're not going to ignore the dead body. It was a one-off. And I'm not criticizing the MFA. I'm encouraging them. I think what they're doing is good. I like it. But from the Crown Attorney's perspective, the MFA has stated quite publicly, we are hiring investigators to conduct large, wide-scale undercover investigations. And these undercover investigations would be unconstitutional if conducted by police officers. So I think that the Crown Attorney looks at that, sees the evidence, and goes, yeah, how comfortable am I pursuing that in the long term? That's what I think. I just think that gut check goes through them. Now, many of them will look at that and go, this evidence is too good to pass up, we'll proceed. But I think there's just that sort of quasi-reluctance to go forward. That's what I think is going on.
Okay, so I will preface this by saying definitely believe, use an animal will go to jail. But my question is about some alternatives that have been coming out. We're talking about designated prosecutors, which I think is awesome in so many ways. Like, that's really great. I know Oregon just has one thanks to ALDF. That's really wonderful. But more specifically, there have been some animal courts that have developed in the country that are like community courts, particularly for cases like hoarders where there's a mental illness component and we're primarily concerned with avoiding the recidivism that happens with that. In a lot of these cruelty statutes, we have the mandated psychological counseling that happens. I think there's like over half the states now at least have that in their thing. But I'm interested in knowing where we're at, if there have been, I was in Arizona at a time where they were starting an animal court. So you get also the judges who understand it needs to be taken seriously, and it's not just on the prosecutor to convince everybody else in the room that this is serious, even though it involves a chihuahua. And then secondly, along the same lines, though, in terms of these alternative, more creative ways, having an animal court, and then secondly, the diversion that usually is used, to my knowledge, mostly with juvenile offenders, such as Anacare, that's been around for a long time. I haven't looked at that recently, but where are we at with that in terms of really trying to get into the psychological aspects when you're dealing with particularly people that are either juveniles or mental illness kinds of issues? I mean, what's happening with that in terms of stiffer penalties and enforced penalties?
There's multiple issues there. Let me first talk about animal court. I think one of the first things we have to understand is that crimes involving animals have two personalities. And I talked to animal control officers about this. On one hand, they protect animals from people, and on the other, they protect people from animals. And often these animal courts are centered around protecting people from animals. So it's the barking dogs, the dogs running at large, and neighbor disputes. So often the animal courts are directed at those types of crimes, not the cruelty and abuse cases. I've yet to see a successful animal court in that regard. But we are moving perhaps in that direction. And also then you have the dispute about, is it state or is it city and county? So you're going to have the city or municipal ordinances in an animal court, but not state charges, which are the more serious cruelty and neglect cases. Number two, your question about the mental health component. I think without a doubt, every hoarding case has a mental health component. I'm convinced of that. And often in other abuse or neglect cases, there's a mental health component. Many states mandate an evaluation and treatment. I'm sorry to report that many judges who are aware of that mandate don't follow it. They'll say, I don't care that the law says I should order an evaluation. Part of the problems is that the Anacare model was the first and only model for a long time, and they are now learning that there's no cookie-cutter approach to animal abusers, and they're developing better evaluation and treatment protocols, and Anacare is even branching out. I do not know of a diversion courtroom. There is a new program by the ASPCA that's dealing with hoarders in New York. This intervention team where it's a multidisciplinary approach to hoarders to try to intervene and let them keep a number of animals and get them the treatment that they need for themselves and for their animals. And what's the other difficulty with hoarders is that the recidivist rate is so high even with treatment. So I hope I answered the question, but it's just difficult to evaluate and treat the offenders. And sometimes, honestly, we have to protect the community from them. And we need to put them into penitentiaries.
No, absolutely. Thank you.
I had two questions. One was for Diane, and one was a question/statement for Peter. One, I wanted to know: is there ALF, HSUS, or any of the major organizations in the U.S. do you guys have a process whereby you get all unreported animal cruelty decisions in a database that are accessible?
That would be no. There is no way that we are collecting data, accurate data, about animal abuse or animal neglect or animal fighting, any of those kinds.
Second thing was for Peter. We need to talk about the unreported cases that you have. If there's anybody else in here from Canada, the Montreal SPCA, along with a number of other partners, is working on a project to get all unreported animal cruelty cases into a federal database and ensure that we keep that up to date. So if there's anybody here, maybe go speak to Peter and I'll speak to him so that we can get our hands on that.
I do know that ALDF is promoting on their website a do not adopt registry as an alternative.
Sure.
I have a question about the prospects for when you're prosecuting people that are employees that have worked in factory farms. It seems like the workers in those conditions, it's really terrible, dehumanizing working conditions. What are the prospects for going after the employers that create that working condition and impose those expectations on the workers?
That's a difficult question to answer because in many instances we cannot prove those cases without the undercover video footage, which brings with it this collective, complex context for the prosecutor. So it's difficult to answer how you go up the chain. But the only way to do it is by videotaping over a period of time.
Can I just segue? I'm not sure I'm even going to answer your question, but I'm going to segue from your question to a question that I want to answer. I'm concerned about the employers, and I'll say that, again, I'm talking about cases that haven't come to light yet, so it's kind of unusual, but the Mercer for Animals cases, a lot of stuff has come up. For example, one of the cases out of BC involved employees who were, the usual stuff. I don't have to tell you, just say Mercer for Animals, it's the usual stuff. It's the employees running around beating animals. But the employees were alleging, that the employers created those conditions. And there were real questions. The charges haven't been laid yet. But, I'm really concerned about whether or not charges are going to be laid. I'm personally not that interested in the employees. I'm interested in the employees. But what I want to know is, when are prosecutors going to treat these crimes like real crimes? Because if you had employees making allegations in the real world, if this was a drug organization, and you had drug organizations captured, and the drug organizations were saying, well, it wasn't me, my superiors were saying X, Y, and Z, you'd have wires on the employees, and they would be trying to go up the chain. And I'm certainly not alleging on camera that the employers are doing this. I'm wondering when we're going to be more interested in the conditions on the farms, because too often what happens is, in every one of these cases, the response from the farm is the same. Nothing to do with it, rogue operator, they went wild, prosecute them, we discontinued them. And every time the response from the employee is the same. This was the condition, this was the way it was set up there. Now in the Kitchener Turkeys case, the farm has been charged. So that's great. But I'm hoping that in all these cases, the prosecutors will really seriously consider taking charges against the organization if the evidence is there to bear it. So it is important to me, and making sure in any reform we take of the statute that liability is able to accrue properly against the corporate entity, because that is an important part of animal cruelty offending. If you can't get the organization, getting the employees is just a tiny piece of the puzzle. It seems to me.
Any other question?
Peter was talking about, this is for Lori or Diane, but Peter was talking about some of the shifts in language that have been happening, like some courts using more animal welfare or seeing more value in animals. Have you seen similar shifts? I know you're talking about differences in sentencing and minimum sentences. Have you made improvements in language in court?
I would echo what Peter said about a designated prosecutor. It makes all the difference in the world. When I was in Denver, I was assigned to a certain courtroom and I had a full felony caseload, but I handled all the cruelty cases. If I walked into a courtroom, not my courtroom, the judges and the prosecutor and the defense is like, here's the dog EDA. And it was immediate. And it makes a huge difference in presenting the case, evaluating it, and getting the sentence. I have found, personally, that the aggravated cruelty cases with the higher mens rea requirement, that I would say, at least in my experience, 90% of them are going to prison. Unless there's some real compelling reason why that would excuse or explain their conduct.
And just to add to what Diane said, from a case law perspective of the appellate court level, we've definitely seen the Nix case is case in point, to use that term. 10 years ago, we would not have seen courts saying that animals are victims given their property status. So that's definitely a huge development, and I would be happy to give you some other cases afterward to that effect.
I've also found that it's a really good tool for prosecutors and lawyers to find language in opinions of cases that have set a precedent, or even transcripts from the trial level of a court that found the act so abhorrent, and use that language in further arguments, in future arguments.
To add to that again, in the Pheasant and Dickey case, going back to the trial court record, it's so important that officers on the stand are saying in their testimony that, this is the most emaciated horse that I've ever seen in my 20 years as a deputy doing these kinds of animal cruelty cases. So that trial, what gets into the trial record is really important.
Yeah, on this language thing, this is more for Peter, I guess. There was a quote that you had in which, for the 8-year-old woman with mental illness or something, said, look, she's lost the privilege of having companion animals by betraying their trust in her. And that is like really strong language. Is there an analog in the Canadian Criminal Code that uses similar kind of language? You say, well, look, we're removing the privilege of you having this sort of relationship. But specifically, I was thinking, does the state talk about this in the same way if you got removal of children from abusive houses?
Yeah, absolutely. That's what's so exciting about the language. I love that case because it's British Columbia Court of Appeal. It's a high court. It's a respected court. Sorry, I lost my voice. Obviously, respected court of major jurisdiction. Good language. Uses the language of children, privilege, trust. It's exactly what we want. So you're right. It analogizes in a way that we can use that type of language for anything, but certainly for getting prohibition orders, certainly for sentencing. You always want to. I think abusive trust language resonates for many reasons, but certainly anytime you're trying to sentence, in our sentencing guide, abusive trust is one of the aggravating principles of sentencing. So I always want to hear abusive trust language in any sentencing case involving an animal, especially where it's the owner abusing their own animal, which to me is an extra added abusive trust. But privilege language is especially useful because to me, the idea of privilege, it cuts so much closer to that idea of guardianship and away from that model property. And I'm not saying judges can
that, but it's a step, it's thinking in that direction.
So thinking about moving forward on a multi-state basis, clearly Oregon can do a pretty good year. Do you think the model moving forward is to have sort of dedicated animal DAs who then have the capacity with resources to find cases with unsympathetic defendants with good facts, and then have the ability to start putting in, not binding of course, but persuasive arguments from other jurisdictions? Or is there another way to identify those really good cases and push them forward?
Just to speak to the designated animal cruelty prosecutor, what we're seeing in counties throughout the country is that, as you said, the resources are really scarce. DA's offices here in Oregon are getting a lot of cutbacks, so we see that model as really promising. And just in Jake's first year, he's had a lot of victories, and he has been in almost every one of the 36 counties in Oregon in some capacity, whether prosecuting those cases himself or just helping out. So we're really hopeful that that model will take hold in other jurisdictions, and we see that as a really great way, because so many times it's not that these counties don't want to take these cases seriously, it's that they don't have the time or the resources or the expertise. You talked about just how complicated animal cruelty cases can be in terms of evidence. So we're hopeful that that model will take hold in other jurisdictions as well.
And as an alternative, the criminal justice program, we offer our services nationwide to the under-resourced, and it's a bit of a fix for them, and they certainly appreciate our collective experience in helping them to analyze the evidence that they have.
I try to say one more thing. I want to take it in the other direction. To me, the point of winning and advancing these cases is not just to get the worst cases and the worst facts. I want my guy in Edmonton to win enough cases that he can take one more borderline cases, because I want to stretch the law. So we've got, in our jurisdiction, some cases that we've been reluctant to go for. And if you win enough cases and you get judges more sympathetic to some of the issues and expressing a willingness to understand, I think, some of the issues, I'm almost hesitant to talk about the issue that I want to target, but so I won't say it. But there's a particular type of establishment that I think everybody has always been reluctant to go after, and I think it's enriched the law. And I think he's made enough of a move in these areas that now you get enough of the facts, and you get enough of the stuff, and you go after it, and you say, we pushed it far enough now on traditional cases that it's time to stretch the law a little bit. So I don't just want to write the clear ones, I want to start pushing it.
That, and also, I was just telling Laura, another concept is that old adage, if you teach a man to fish. So I think it's our job to not necessarily have one prosecutor in the state, it's to have that prosecutor teach one in every jurisdiction to take, and run with it.
Maybe it's one more question if anybody has a question.
I think this is going to be a pretty simple question. Does that mean having a dedicated prosecutor in every county in your state?
I think what the reality means is you find a prosecutor in that jurisdiction that has an interest in these types of cases, and they will agree to take them on in addition to their caseload.
Because there aren't enough cases, fortunately.
Correct. So they're not going to be able to give up what they are already expected to do. So it will be a labor of love.
But it's interesting because, and correct me if I'm wrong, but a serious animal abuse case is analogous to spousal abuse, domestic violence, and also child abuse. So that's,
How about a case with over 100 cows? I mean, that's going to be very labor intensive, but there's somebody that'll take it on, I believe.
Okay. Thank you guys for listening.
So,